If you are a victim of domestic abuse, you may be wondering what legal options you have to keep yourself safe. One of your options is a Victims Protective Order. A VPO is a court order that protects a victim of domestic abuse, including threats of imminent physical harm, and victims of harassment, stalking, or rape. The order prohibits the defendant from contacting or attempting to contact the victim. Violations of a protective order may result in criminal charges. The person requesting a VPO is the plaintiff. The person being served with the request for a VPO is the defendant. Once the VPO petition is filed, the defendant will be notified and a hearing date will be set to see if the VPO will be issued. You have a right to hire an attorney to represent you at the hearing. It is your responsibility to find and pay for the attorney. If you don't hire an attorney, you represent yourself at the hearing. If your VPO request involves stalking by someone who is not a family member, someone you were dating, or someone you lived with, you must file a police report before you request a VPO. Anyone 16 and older may request a VPO by filling out a form available at the court clerk's office. If the victim is under 16, an adult living with the victim may file the form for them. It is important the plaintiff attends the hearing, otherwise it will be dismissed. If the defendant doesn't go to the hearing, the judge may enter an order against them. At the hearing, the court clerk, judge, and your attorney will guide you through the process. When you enter the courtroom, sit on the opposite side of the courtroom from the other party in your case. Be sure to turn off all electronic devices. When the judge enters the courtroom, stand up. When your case is called, approach the judge's bench. The judge will ask the plaintiff to state their case and show that you were harmed by the defendant's actions described in the petition. After the plaintiff is done, the defendant gets their turn to prove the plaintiff's claims are then false. Defendants may cross-examine the plaintiff or the plaintiff's witnesses. Both sides can use documents, photos, and witness testimony as evidence. The judge cannot consider evidence or witness testimony if the evidence or witness isn't at the hearing. After both sides are heard, the judge may ask the defendant if they agree to the VPO. If the defendant agrees that all the information and allegations from the case can be used as evidence in other court cases that the defendant may be involved in. If the defendant does not agree, the judge may still decide to issue the VPO. Defendants shouldn't leave the courtroom without a copy of the VPO. The judge will decide who pays for court costs. If the judge dismisses the case, the plaintiff may be ordered to pay court costs. If the judge needs more information, another hearing will then be scheduled. Here are 6 tips to help you at the hearing. 1. Arrive early. 2. While court is in session, be quiet. You can speak when the judge calls on you. 3. Do not lie under oath. If you do, you could be punished for contempt of court or perjury. 4. Don't interrupt the bailiff, judge, parties, or any of the witnesses. 5. If you have questions before the hearing, ask your attorney or the court staff. 6. If you have questions during the hearing, ask the judge. For more information, go to okbar.org or contact your local court clerk.